Welcome everybody to our presentation today on the sort of what are the new labor and employment laws coming up for 2021, some of which have already taken effect. I'm sure you're all curious to know what's going on in the Wild West of California labor and employment law. But before we begin, I want to introduce our speakers today. So why don't I start with Alicia Anderson, who is a counsel in our Los Angeles office. Obviously, we all do labor and employment law, but Alicia also focuses in sort of our labor relations and union type issues. So she's part of our union avoidance team and deals a lot with the NLRB and other labor relations types issues as well. So she's one of our speakers today. Also speaking today is Hillary Baca, who is a senior associate in our San Francisco office. Hillary does a lot of advice and counsel work, as well as she does defend various companies in a variety of different litigation. So I want to welcome Hillary to our speaking panel. Next up is Rachel Kahn. I work with Rachel and our OSHA group. Rachel focuses on occupational safety and health and workplace safety, which has been a pretty big issue this year, given everything that's going on with COVID. You might recognize her from all the other COVID-19 webinars we've done this year. I think Rachel's been on all of them, and so she is really our go-to person when it comes to OSHA. But last but not least, we have May Howe, who is a senior associate in our Los Angeles office. May is one of our go-to people when it comes to advice and counsel, particularly with respect to employment agreements and severance agreements. And she also obviously handles a variety of different types of litigation. So thanks everyone for joining us today. And without further ado, I want to turn it over. Before I turn it over to Hillary, let's go over a couple of things that we're going to cover today. One is that we're obviously going to cover new California employment laws, as well as recent cases that will affect perhaps various types of employment issues coming up for 2021. And we'll also talk about OSHA, workplace safety, and particularly with respect to COVID-19, which unfortunately is still ravaging the country, and as many of you know, will be a big issue for 2021 as well. And last but not least, we'll be covering a variety of updates from the NLRB on the labor relations side. So now I'm going to turn it over to Hillary to take us through the new employment laws and cases.
Thanks, Ben. Good morning, everyone, or good afternoon, depending on where you are, I guess, but probably in California. So I'm going to walk through a few of the new laws that are going into effect at the beginning of the year. If a new law is already in effect, it'll be noted on my slides, but otherwise you can pretty much assume that it'll be in effect on January 1st. So the first law I'm going to talk about is Assembly Bill 2257 and then Prop 22, which both amend AB 5. I figured a little history might be helpful. You probably all remember that in April 2018, the California Supreme Court came down with a decision in a case called Dynamex, and it set forth a much more stringent test for determining whether a worker is an independent contractor or an employee. The legislature then decided to codify that Dynamex test through the passage of AB 5, and that went into effect at the beginning of this year on January 1st. It codified what people now refer to as this ABC test, and the test basically says that to be properly classified as an independent contractor, the hiring entity has to show three things: that the worker's free from the control and direction of the hiring entity in connection with the performance of the work, and this has to be both under the contract but also in fact. The worker performs work that's outside the usual course of the hiring entity's business. And then the third factor is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. This ABC test applies for purposes of the labor code, the unemployment insurance code, workers' comp, the wage orders, basically everything under the sun. What 85 also did, it codified this ABC test, but it also exempted a whole host of occupations and service providers from this ABC test, and instead made them subject to a much more flexible multi-factor test. And that test is called Borrello, after the case it came from. AB 2257, what it does is it basically expands the very long list of occupations that are exempt from the ABC test and instead fall under the Borrello test. These include a lot of fine arts occupations and services, so occupations in connection with creating, marketing, promoting, sound recordings or musical compositions. It exempts a musician or a musical group for the purpose of like a single concert or a single engagement live performance. It exempts artists presenting material that is their own original work as long as it's creative in character. There's kind of a whole host of these kind of fine arts occupations that are now included in the exemption. In addition to all of those fine arts occupations, the bill also exempts people who provide underwriting inspections or other services for the insurance industry, landscape architects, real estate appraisers, home inspectors. So it's a crazy slew of new occupations that are now exempt from this ABC test. So the bottom line is that if you're considering classifying someone as an independent contractor, you really have to go through the new revised text of AB5. It's in Labor Code Section 2750. You really have to go through it with a fine-tooth comb to determine whether you have to satisfy the more stringent ABC test or whether you only really need to look at the multi-factor test. I think this is great news for some employers who work with people who fall into these new exemptions. But it also makes complying with AB5 more difficult, right? Because there's a lot more nuance now and law to get through and read and apply. AB 2257 also clarifies some of the business-to-business relationship and professional services exemptions. So those are tweaked. Generally, it's expanded them a little bit, but they're largely the same. Lastly, I just want to mention that AB5 was further modified by the passage of Prop 22. So this was the ballot measure in California that was funded largely by DoorDash, Lyft, and Uber. The measure considered app-based drivers to be independent contractors and not employees. So basically overrode AB5 and the ABC test. The measure also adopted labor and wage policies specific to these app-based drivers, including the payment of like a floor wage, limiting their total working time, and providing healthcare subsidies. So if you're a company that relies on gig workers, you might take a close look at the language of Prop 22 because it could be potentially very helpful for you. The next bill I want to talk about is Senate Bill 1383. This is a really big deal for smaller employers with less than 50 employees. So essentially what this bill does is it expands protection of the California Family Rights Act, also called BFRA, to employers with 5 or more employees. Before this bill was signed, BFRA only applied to employers with 50 or more employees. So what this means for small employers is that you're now prohibited from refusing to grant up to 12 weeks of unpaid leave during any 12-month period for employees to bond with a new child or to care for themselves or an ill family member. It puts a pretty significant new burden on smaller employers, and smaller employers are also going to want to look at their handbooks or their leave policies to make sure that they now incorporate this, because the vast majority of small employers probably didn't have a CFRA or an FMLA policy before now. So time to look at your policy. Senate Bill 973 relates to employer pay data reporting. This one is for the larger employers. So it requires employers with 100 or more employees to file pay data with the California Department of Fair Employment and Housing. It applies to those employers who have to file an annual employer information report. This is also referred to as an EEO-1 report, to the Federal Equal Employment Opportunity Commission. So if you file an EEO-1 report now, you are also going to have to comply with this special pay data reporting in California. Employers have been required to report demographic information to the EEOC for a long time. In 2016, the Obama administration announced its intent to expand the EEOC reporting requirements to include employee pay data by race, gender, and ethnicity. But then the current administration decided that it was not going to collect such data from employers. So the Obama administration idea or announcement kind of never came to fruition at the federal level. SB 973's legislative findings declare that its intent is to ensure that this pay data will continue to be compiled and aggregated in California, notwithstanding the policy change at the federal level. So it's in direct response to the current administration's decision, basically. The report that employers have to submit to the DFEH has to contain data that includes the employer's total number of employees and total hours worked by race, ethnicity, and sex in all the job categories that you'd normally report on your EEO-1 report. The first report is due to the DFEH on March 31st of 2021, and then by March 31st each year thereafter. An employer with multiple locations in California, unfortunately, has to submit a separate report for each location, as well as a consolidated report. The DFEH can share these reports with the California Division of Labor Standards Enforcement, the DLSE, and the DLSE is basically in charge of enforcing the state's wage and hour laws. So they can kind of share information, trade facts on employers. The DFEH also is empowered to investigate and prosecute complaints that it receives on its own. So if it receives a complaint that an employer's pay practices discriminate based on race or gender, it can go ahead and pursue that kind of in its own capacity. All right, the last one I'm going to talk about is Senate Bill 1159, and this relates to workers' comp claims for COVID-infected employees. So Governor Newsom signed an executive order which created a rebuttable presumption that certain employees who tested positive for COVID contracted the virus at work, which made them eligible for workers' comp coverage. SB 1159 basically takes over from that executive order. So you know, the specifics on the slide, and I just want to caution that the law is very detailed. So this isn't everything that's kind of in it, but here's some of the highlights, I guess. But if between March 19th and July 5th of this year, an employee tests positive, within 14 days after a day when the employee worked on site at the employer's direction, then the employee basically is eligible for workers' comp benefits. Then after July 6th, kind of the same test applies, provided that the employee contracted it during an outbreak in the workplace. So with that, I'm going to hand it over to my colleague, May Howe, to walk you through some of the new case law that came down this year that's important for employers to know about.
I'll address a few notable, hi everyone, I'll address a few notable decisions that were issued in 2020 that may be of interest to employers. The first is McPherson versus EF Intercultural Foundation. Prior to this case, there had been no published decision addressing an unlimited vacation policy, despite the increasing popularity of such policies. As you may know, an employer is required to pay out any accrued but unused vacation upon termination of employment. This is because California Labor Code Section 227.3 treats accrued vacation as wages. A key benefit of an unlimited vacation policy then is that it doesn't require the payout of vacation upon termination because vacation doesn't accrue under such a policy. In McPherson, the company had an unwritten policy for area managers where they could take time off with pay, but they didn't accrue vacation. The area managers did not use the company's online system to request time off, and their vacation wasn't tracked. Instead, they were required to notify their supervisors before taking time off, and taking time off during the company's peak season was strongly discouraged. The plaintiffs here sued the company for its failure to pay them accrued but unused vacation wages upon their termination. They argue that the company's unwritten policy of providing an alleged unlimited vacation was instead a de facto use it or lose it policy. The court ruled that the company owed the area managers vacation wages because the so-called unlimited vacation was neither unlimited in practice nor conveyed as unlimited. Here, the court found that the policy had an implied cap on vacation, since the company expected the area managers to take between 2 to 6 weeks of vacation per year. Accordingly, it wasn't an unlimited amount of vacation. The court also ruled against the company because it never communicated the unlimited nature of the vacation policy to the area managers. The court limited its holding to the specific facts of the case and noted that a true unlimited vacation policy may not trigger the payout requirements under Section 227.3. Such a policy must be in writing, must clearly state that an employee's ability to take paid time off is not a form of additional wages for services performed, but instead is part of the employer's promise to provide a flexible work schedule. The policy must also spell out the rights and obligations of both the employee and employer and the consequences of failing to schedule time off. The policy must, in practice, allow sufficient opportunity for employees to take time off or work fewer hours in lieu of taking time off, and it must be administered fairly so that it does not become a de facto use it or lose it policy and does not result in inequities. Employers that have unlimited paid time off policies or are considering implementing these policies should evaluate or update these policies to avoid any unwanted wage obligations. Two other notable cases from this year address the issue of compensable work time. In general, an employer must compensate non-exempt employees at least the minimum wage for any period of time in which the employee is subject to the employer's control. In the first case, the question was whether an employer was required to compensate its drivers for time spent on layovers and rest breaks. The Ninth Circuit answered yes. In this case, a key question was whether Walmart was required to pay its drivers for time spent on layovers, which generally lasted 10 hours. Walmart's policy required the drivers to seek pre-approval before they took their breaks or layovers at home. The policy also stated that drivers could be disciplined for taking layovers at home without prior approval. The court found that if Walmart's policies directed, commanded, or restrained employee conduct, such that the drivers were not free to spend layover time as they saw fit, then control existed. And because Walmart exerted control over how the drivers were to spend their layover, the court ruled that this time must be compensated. In the second case, the question was whether employers were required to compensate employees for time spent undergoing exit searches. The California Supreme Court ruled that this time is compensable. In this case, Apple had a policy that required its retail store employees to undergo exit searches of their bags and personal devices before leaving the store. This usually took anywhere from 5 to 20 minutes, with some lasting up to 45 minutes. The court found that this time must be compensated as hours worked because the employees were under Apple's control during the searches. The factors that informed the court's analysis were that the searches were required as a practical matter as most employees brought their bags and personal devices with them to work. The searches occurred at the workplace and involved a significant level of control. They were imposed primarily for Apple's benefit in deterring theft, and they were enforced through threat of discipline. The takeaway from these two cases is that if an employer imposes any requirement or restriction in how non-exempt employees should use their non-working time, it is still considered compensable hours and must be paid at least minimum wage. Employers should visit their policies and practices to determine whether they place any off-the-clock control over employee activities that may require compensation. Employers should also be aware that the holding in this case is retroactive, which means that they may be subject to claims for unpaid wages reaching back several years, even if they do revise their existing policies and practices. And now I'll turn it over to my colleague, Rachel Kahn, to talk about updates with OSHA.
Thanks, May. As many of you know, here in California and in the country, countrywide, there's been a lot happening with OSHA this year because of COVID. I'm going to be talking about two main things that are happening in California, but there's much more going on, so I apologize for trying to get in as much as I can here on these two most important things that are happening in California currently. First, we have AB 685, and that is a new statute that was a bill that was signed by the governor in September. It goes into effect on January 1 and will stay in effect till January 2023. And this bill basically does three things. One, it clarifies that Cal OSHA has the ability to shut down a business, a workplace, if there is an immediate hazard of COVID. Cal OSHA has always had that ability, but this was just clarifying that COVID is a reason that they can do that. The second thing that this bill does, which is the one that's probably going to affect most people, is the exposure notifications to employees, employee representatives, the employers of subcontractors, and public health, should you have a potential notice of COVID exposure at your workplace. So this requires written notice within 1 business day of any notice of potential exposure in your workplace. And there's a lot of definitions. If you haven't read this statute yet, please do, because there's a lot of definitions in here that are make a difference about what is specific to what requires in the notification, what is the required scope, being the workplace, infectious period that counts. And so this is one that is going to affect everyone. It's going to apply to everyone. And there are also additional requirements that have to be provided into that written notice to employees, as well as record-keeping component of that. And should an employer not do comply with this part of the statute, Cal OSHA can issue citations for it. So this is one that employers should definitely be focusing on now, making sure you understand the rule and having template notices in place, and that's certainly things that we can help you with as well. In addition, what this bill does is it limits what Cal OSHA needs to provide in terms of 1BYs. And for those of you that may have not had much experience with Cal OSHA inspections, essentially what that means is that when Cal OSHA does an inspection, before they issue citations for a potentially serious citation, they have to give the employer notice and 15 days to respond. This bill now scraps that notice requirement for COVID-related citations. The theory behind it is that because of the COVID epidemic, this will allow Cal OSHA to issue citations sooner. So that is AB 685 in a nutshell, but again, particularly when it comes to the exposure notification part, I would encourage you to make sure you read that and understand your duties under that one. So next, I'm going to talk about the new Cal OSHA COVID regulation that went into effect on Monday. It's an emergency regulation. It's 21 pages. It's long. It's dense. There's lots of requirements in there for employers. This was pushed through very quickly. It was stakeholders, the public only had 5 days to review the draft of it before it went to a vote to the Standards Board. And then on Monday, it was approved by the Office of Administrative Law and went into effect immediately. So this is now in effect. It applies to all employees in the state of California in all places of employment with very, very limited exceptions. If there's only one employee and that employee works by themselves and isn't in contact with others, people that work from home. For healthcare employers, there is some overlap with this in the ATD standard. So if you are subject to the ATD standard, you're definitely going to want to either reach out to us or really look at the FAQs that Cal/OSHA has put out on this to understand how Cal/OSHA is interpreting the interlay between these two standards. With that, Cal/OSHA has released FAQs in a template program on their website there that you can take a look at that as well. And one of the main things that this standard does is that it requires that all employers have a COVID prevention program. I know when I talk about this with most employers, they say, oh, we have a policy, we have a program, there's probably not a heavy lift for us on this. And, you know, what I want to caution everybody about is that, again, this is a 21-page, single-space standard. It's very dense. There's lots of specific requirements in it. So even though you have your policies and procedures in place, you're going to want to make sure that they're compliant with this standard. The template program alone that they released is about 20 pages, and that's without putting in the employer's own information. So I'm just going to quickly go through. There's 11 elements that are required for this program. I'm going to go through those elements, and then I've picked out, there's numerous requirements under each element, and I've just picked out some of them that have popped out to be some of the more interesting ones to flag to you so you get an idea of what some of the requirements are. So first, there has to be a system for communicating the plan and program to your employees. And one of the requirements under this is to have policies and procedures for accommodating employees with medical or other conditions that put them at an increased risk. The next element is an identification and evaluation of COVID hazards, and this requires conducting a workplace-specific assessment of all activities, areas, equipment, anything that could potentially expose your employees. Third, there is an investigating and responding to COVID cases. There are specific notice requirements in here, and I want to flag for you that these are different than the AB 685 notification requirements. So these are more narrow and potentially will require 2 separate notifications. So one bucket of employees that are exposed under this standard and one that are on we're on the premises of a work site under AB 685. So I do want to point that out. It also requires that employers offer COVID testing at no cost to employees during their work hours when they've had potential COVID exposure at the workplace. There's a correction of hazards. That one's pretty self-explanatory. Training element. The training, it provides a list of required training. And so you're definitely going to want to make sure that you take a look at that and make sure that even though you may have already done training for your employees, you're hitting all the elements that are listed in that program. Physical distancing, and this includes all employees must be separated by at least 6 feet, except for where the employer demonstrates that 6 feet is impossible. So make sure that's a tricky standard that requirement that Cal/OSHA has put in there to put the onus on the employer to make sure that there's really no way of keeping people 6 feet Face coverings need to be worn indoors and outdoors when less than 6 feet apart. For other engineering controls, admin controls, and PPE, one of the things they have listed there is that to install cleanable solid partitions where it is not possible to maintain 6 feet of separation. In addition, there are reporting, record keeping, and access requirements with, as you can see there, very specific what a record includes and what needs to be tracked. There's lots of information there that's very specific. OSHA likes to pick at when employers don't include every specific piece of that in the record keeping. There's the exclusion of COVID cases from the workplace, and when you are required to exclude those people that are COVID cases or may have been exposed. And please note that the quarantine period listed in this is different than the new CDC guidance that we've seen come out yesterday. And given that this is a regulation, OSHA can't just they would have to amend the regulation to change it. So what you're going to see is OSHA having a different legal standard than potentially the CDC. Now, one other thing to point out here is that employees excluded from the work site because they've been exposed through a work-related exposure, that employers now have to continue and maintain the employee's earnings during that time that they are excluded from the work site. And the onus is put on the employer to demonstrate that the exposure was not work-related. Finally, there is the return to work criteria, and which is similar to what we've seen before the 10-day period after having COVID. But I'd also like to note in here that it does not allow a negative COVID test cannot be required for the employee to return. Finally, that's the piece of it that goes over the plan, but there are also 4 additional sections to this regulation that apply to when there's been multiple COVID infections at the workplace, 3 or more COVID cases. There's a whole other section about testing and requirements for employers to follow there. When there are major COVID outbreaks, hopefully nobody will have one of those. There's additional specific requirements. If you provide employer housing, there are specific requirements there. And if you have employer provided transportation, there are specific requirements there as well. So I do want to flag those for you. And again, I encourage all employers to take a look at this standard, to reach out to us if you have questions. It's in effect now, and it's complicated and it's dense. And with that, I will turn it over to my colleague, Alicia Anderson, to talk about labor updates.
Thanks, Rachel. I'm going to advance the slide here. Okay, it's not working. Give me 1 second here. All right, there we go. Okay, so I'm going to talk to you all a little bit about what's happening with the NLRB and what we can look forward to next year, particularly as we have a change in administration. So taking a step back, the NLRB is really one of those federal agencies where the law can really shift quite dramatically based on the party of the president. So what we've seen is that the Obama-era board was really quite labor-friendly, made a lot of groundbreaking law in different areas, really pushed close examination of employee handbooks, even outside of unionized workplaces. The Trump-appointed board was comprised mostly of management side attorneys, and as such, they really worked to undo some of the sort of far-reaching Obama-era board decisions. So I'm going to highlight for you guys what some of the key decisions have been under the Trump board, and then sort of what we can look forward to under the Biden administration. So really quickly, I'm just going to sort of talk about the board membership. So the board is comprised of a 5-member board. Each of the positions is a presidentially appointed position confirmed by the Senate. You'll see in the photo there that there's only 4 board members in the picture. That's because since August of 2018, there's been a vacancy for the Democratic seat. Traditionally, the board is made up of 2 Republicans, 2 Democrats, and then the chairman comes from the president's party. So what was likely to happen is that when President Biden takes office, President-elect Biden takes office, he will have the ability to appoint that vacant board member seat for the Democratic vacancy immediately. However, he won't be able to change the composition of the board until William Emanuel's term is up in August. So that is sort of what the composition will look like. I will note that in all likelihood, the chairmanship will be passed to the remaining Democratic member, Lauren McFerrin, or the new board member could take over the chairmanship. That being said, because the board is an adjudicative body, it will require a Democratic majority in order to really make fundamental changes in terms of board decisions, because it's conducted by vote. So the next position that is also a presidentially appointed position is the NLRB General Counsel. And really where the board is an adjudicative body, it can only take up the cases that come before it. The General Counsel is the top prosecutorial position. And the General Counsel also supervises the network of regional offices that across the country. And the regions are the ones who investigate and prosecute complaints that come before it based on unfair labor practice charges that are filed by unions or employers or really anybody. So in that role, the General Counsel really has quite a bit of power in terms of the functioning of the board, in terms of policy decisions that are made and policy priorities that the board has in terms of what complaints get issued. Certainly the General Counsel is required to follow board precedent and enforce what the decisions that the board makes, but because he is a prosecutor, he really can sort of direct policy. So his term doesn't expire until November of next year. There is a new Supreme Court ruling that came out recently where the logic of the unitary executive gives the president the power to fire the director of a federal agency because if they have policy differences. Certainly, Peter Robb, the current General Counsel, is going to have policy differences with the new incoming Biden administration. So it will be really interesting to see because this has never happened before. Historically, presidents allow the General Counsel to serve out their term before they go ahead and appoint one. But if the Biden administration wants to act quickly in terms of labor policy, labor management policy, they may very well use that new power to make a change in terms of who the General Counsel is. So a few recent developments, specifically this section is going to go over developments that impact workplace rules. As I stated, the Obama-era board, their hallmark was really looking closely at policies and handbooks and scrutinizing them to determine whether or not facially neutral rules may impede on an employee's ability to organize in the workplace and act in concert with each other. So under the Obama-era board, we had a whole bunch of policies that would seem to be on their face, have nothing to do with unionization, and they were struck down. So in the Boeing company, which is a December 2017 decision, the board came up with this new framework, basically saying that things had gotten out of control, and we want to dial that back a little bit. So under the Obama-era board, the test was that work rules are unlawful if the employer would reasonably construe the rule to restrict the protected concerted activity, and that would reasonably construe, that became just wild for the board to sort of, for the regional directors and the administrative law judges to sort of decide that any rule could conceivably reasonably construe, be reasonably construed to protect concerted activity or to restrict concerted activity. So under the new test, the board will find a facially neutral rule to be unlawful if it explicitly restricts concerted activity, in which case it wouldn't be facially neutral. But if not explicit, then they're going to look at what the rule's potential impact on protected concerted activity is and what the employer's legitimate business justification for the rule is. So bottom line, it's a balancing test. If the justifications outweigh the impact on employee rights, the rule will be determined to be lawful. The board went even further and announced that going forward, to help give some guidance, because there was sort of this black hole of whether a rule would be determined to run afoul of the National Labor Relations Act or not, the board decided that it would come up with these three categories, and it would make precedent based on whether a rule was presumptively lawful, that's a Category 1 rule, whether the rule really does warrant individualized scrutiny in each particular case, so that, you can make a determination about whether there's interference with NLRB rights in the application of the rule or in the rule itself. And in Category 3, these would be rules that the board would say, yeah, no question, a rule like this is going to be presumptively unlawful. So looking at this new framework in practice, in the Boeing Company case, the specific policy that was being evaluated had to do with a rule that Boeing had in place that prohibited cameras in the workplace. And certainly we can all come up with, a really good reason, trade secrets, national security, et cetera, about why Boeing in particular may not want employees to be walking around with cameras in the workplace. So the board looked at this rule and determined that this was a Category 1 type of rule where the employer's justification was, exactly as I said, protecting trade secrets, employee personal information, national security, et cetera. And this rule effectively overturned a hallmark Obama-era board case called Whole Foods, which there was a similar no recording rule that Whole Foods had come up with that on its face was specifically aimed at fostering employee-free expression. They didn't want employees to feel like they couldn't speak out in the meeting because they were being recorded by somebody else. So interesting absolute flip on the no recording rules based on this new framework. Additionally, one of the hallmarks of the Obama-era board was that these sort of workplace civility rules, most employers in their handbooks, they have sort of this preamble where they say, we encourage employees to respect each other and, try and get along, that kind of thing. And the Obama-era board was really quite harsh on those rules but based on the rationale that these rules could inhibit employees from, speaking out if they disagree with management. So in the new standard, the board really said that many of these types of civility rules, these should be Category 1 rules. These are presumptively lawful rules. Another case that came out of this new framework was this Apogee retail case from last year, late last year, where the Category 1 type of rules, the rule that was under review was a rule that required confidentiality during the course of a workplace investigation. Certainly there's good reason for why it makes sense to do so. And so the board said, yeah, we're going to find that there is that good reason is presumptively lawful. The rule can be presumptively lawful where the confidentiality is required for the duration of the investigation. But we're not going to go so far as to just say that a blanket confidentiality rule is required. It is always going to be lawful. So where the rule requiring confidentiality is not limited on its face to the duration of the investigation, then the board is going to call that a Category 2 type of rule, where in order to determine whether the rule is legal, they have to go engage in that balancing. Another big case to come out is the Caesars Real All Suites case that came out in, again in December of 2019. Those of you who have unionized employees are in all likelihood aware of the Purple Communications Rule. What Purple Communications did is it required employers to make their company email available to employees for union organizing, fundamentally. So the Caesars Real All Suites case, or Caesars Entertainment Court case, overturned Purple Communications and found that employees do not have a statutory right to use the employer's email system for those statutorily protected purposes. So they can be banned from using the employer's email in order to unionize. I'm going to briefly talk about union elections. There's been some pretty key changes in terms of rules of how elections are conducted under the Trump board. So when the Obama board was, under the Obama board, there was a set of rules that came out that we call the quickie election rules, where the real intent of the rules was to speed up and modernize certain aspects of union elections. When an election petition is filed, to try and speed the process through for the vote. Previously, employers would try and drag out the proceedings because the longer that you would go between the time of the petition for election and the actual election, that seemed to be better for the employer in terms of defeating unionization. So, this new set of rules came out with, much more abbreviated time frames in terms of how elections get conducted, and changed procedures fairly dramatically. The vast result is that it actually really didn't increase the percentage of elections that were won by unions, but nevertheless, it was a headache for employers to try and comply with the shortened time frame. So the Trump board issued revised rules on December 15th of last year. Notably, this was a public notice and comment period. So in May of this year, the DC District Court enjoined some parts of those rules for violating the Administrative Procedures Act. Very quickly after that injunction was in place, the General Counsel, the very management-friendly General Counsel, issued an advice memorandum implementing immediately whatever was not enjoined. So, I'm not going to go into the nitty-gritty of all of the different rules, but I will say, if you're facing a union election, you want to make sure that you're paying attention to that advice memorandum, at least until the rules change again. And that you're following all the requirements, because there are still some, time frames and deadlines that employers need to be aware of when they're facing a union election. Another big development in union elections was there's always a debate between employers and management regarding the size of a bargaining unit. The idea being that it can be difficult for a union when unionizing a new workplace to convince all of the workers in the workplace to unionize, to join the union. But if a union can break off a smaller piece of that workplace in what's called a micro unit, then they can convince that smaller group, a majority of that smaller group, to unionize. And once they're in the door, that gives them entree to unionize the rest of the workplace. So under the Obama era board, there was a case called specialty healthcare that allowed unions to really kind of define whatever shape of union that they want, whatever shape of bargaining unit that they want. And it put an incredibly heavy burden on the employers to prove that the employees that were excluded from that unit share an overwhelming community of interest and therefore should be included in the larger unit that the union is trying to organize. So the PCC structural case went back to this traditional sort of community of interest approach, where it's a much looser standard and more favorable for employers trying to challenge those micro units.
One brief note on the PCC structurals case, that case is actually before the DC Circuit, so we'll have to see next year whether that continues, but it's currently up for federal review. And in any case, we do expect that under the Biden board, we may see some movement in terms of what that unit definition is. Just noting that the Boeing company, another Boeing company case, not the one about recording rules in the workplace, but this is a case that came out again last year where it clarifies that the PCC structurals case contemplates a three-step process for determining the appropriate size of the unit. Another thing to come out of the Trump board were a couple of cases that impacts union rights and essentially curtails them. So we've got a case that came out December of 2019 again, which found that after a collective bargaining agreement expires, the dues checkoff part of the bargaining agreement will also expire. So the employer doesn't have to continue to remit union dues to the union after the agreement expires. So this is a big deal because obviously unions get their money to continue to function from the dues that the employees are paid. So it creates some incentive for a union to, come to the table and try and get a new bargaining agreement in place so that they don't lose the ability to have the employer collect the dues on their behalf and remit them over to the union. There also were a couple of cases that restricted union access to property, particularly if they're not already in the door. I'm not going to go into the specifics of these cases, but the law has definitely shifted there in terms that are more favorable to employers being able to say, we're going to, prohibit these outside entities from coming onto our property and leafleting or conducting meetings, that kind of thing. Another development was a new rule that went through the board's rulemaking processes on joint employer liability. What this fundamentally means, so that this is a fairly hot issue, both in terms of outside of traditional labor and inside of traditional labor, where really what these cases, we call them the McDonald's cases, they tend to examine whether or not in a franchise model, the franchisor, so Big McDonald's, is on the hook for the actions of the franchisee, so the individual, McDonald's down the street from you. And the joint employer rule that was put out by the NLRB effectively cut off that liability for, at least for traditional labor purposes. So the terms are here, and again, I'm not, in the interest of time, I'm not going to go into many specifics on this, but it's definitely worth taking a look at, particularly if you're in a franchise model. Okay, so there's a lot more happening with traditional labor than what we were able to cover today, but I wanted to highlight a couple of things to sort of watch out for next year, and to watch out for that we expect to be major developments under the Biden administration. So first, as we talked about, the appointments are going to be interesting to see, and whether or not President-elect Biden decides to remove the current general counsel before November 2021. Certainly the outcome of the election in Georgia is going to have an impact on traditional labor, because in the past, under Obama's presidency, the Republican-led Senates were particularly hostile to Obama's ability to appoint NLRB board members. At one point in time, there actually wasn't even a quorum, which prohibited the so that means there was less than 3 members on the board, and it prohibited the board from being able to make any policy decisions during that time period. Another interesting, I know there was a question about the PRO Act, and I do want to make note of that. So the PRO Act stands for Protecting Right to Organize. It's an act that was passed by the Democratic House earlier this year, but has not been taken up by the Senate at all. And I think it's a particular note because President-elect Biden's policy platform on labor basically says that not only endorses the PRO Act, but also says that the incoming Biden administration wants to go even further. So what the PRO Act would do, if passed, is radically modify some of traditional labor, the shape of traditional labor in the United States. It would expand protections of the NLRA to more workers by adopting a more narrow criteria to classify workers as independent contractors. So what Hillary was talking about earlier about AB5 and the ABC test, that definitely seems to be where the Democratic members of Congress are pushing for, like a much more broader definition of who's an employee. And a couple other interesting things that are in the PRO Act, it would enable the NLRB to levy civil penalties against employers who commit unfair labor practices. Currently, there is no monetary penalty. If you violate the NLRA, fundamentally you can be required to pay back pay or hard damages to a union or to union members, but you but there's no actual penalty, monetary penalty for violation. You just do a posting. So that would be a fairly dramatic change. Another major change would be it would overturn the overturning of purple communications, so it would open up again the employers' electronic communication systems to union organizing. And it also gives workers the right to bring a civil action in a federal district court against employers for committing unfair labor practices after a 60-day period expires after filing a charge with the NLRB. So that would be a fairly dramatic change, because right now the NLRB is the only place for those workers to have their rights adjudicated. So I think that's it. One other point, a lot of times we get some really interesting cases in December, so look out for that. And with that, I'm going to turn it over to Ben, who's going to wrap us up.
Thanks very much, Alicia, and thanks to Rachel, Hillary, and May, and everyone who put together today's presentation. We are going to jump to Q&A, a short Q&A, but before we do that, I want to announce our CLE attendance verification code. You can see it there on the screen, but it is also NPCLE 120320. And there's some instructions there on how you can get your CLE certifications. And so we received a couple of questions, and so I want to go over some of that. I know we're at the 1 hour mark, and some of you may need to jump off. A recording and the presentation slides will be made available again through an email that we'll send out to all registered participants. So if we have your email address, you'll get a copy of those links, and so they'll be made available. So with respect to questions, we received a couple of questions with respect to Senate Bill 973 and the EO reporting, and whether or not the 100 employee requirement includes just the employees in California or everywhere around the country. And Hillary, do you want to answer that question?
Yeah, I do. So the bill definition of employee does not limit it to employees working in California, so the answer was unclear. But since the bill was signed, the DFEH has come out with FAQs online stating that employees located inside and outside of California are counted when determining whether you have 100 or more employees. So if you've got 50 in California and 50 in Texas, then you have to report on those California employees.
Thanks, Hillary. We received a COVID-19 related question with respect to the new regulations and whether or not an employer can require an employee to provide evidence of a negative COVID test before their return. Rachel, do you want to take that one on?
Sure. So under the new regulations, after a employee has been a COVID case, meaning that they were positive for COVID, they had a positive COVID test, and they complete the return to work criteria under the standard, which is the 10 days, some symptoms or an improvement, no fever for 24 hours, and then the 10 days if they're asymptomatic. The standard says that you cannot require a negative test for returning to work under the new standard.
Thanks, Rachel. Another related question with respect to the new regulations, there was a question about, well, if an employee exhausts all of the sort of the FCRA leave or paid sick leave, what do we do about this requirement in the regulations that we have to maintain their level of compensation and benefits during their quarantine period?
Yeah, so the regulation does allow for certain, they call it public benefits, to be used to meet the employer's requirements to maintain earnings. But ultimately, at the end of the day, it's going to be the employer's requirement to pay to maintain those wages if there's no additional public benefits available, or if workers' comp isn't going to cover it. At the end of the day, that's going to fall to the employer.
Thanks, Rachel. All right. So a couple of things that we wanted to cover before we end today. So if you're a current client of Nixon Peabody, there are a couple of things that we have for you. One is a foreign policy that complies with the amended California Family Rights Act that was covered today. Obviously, the big buzz around town right now is the COVID-19 regulations. There is a model policy provided by Cal OSHA on its website. There are FAQs, but one thing that we can provide as well is a COVID-19 policy toolkit that will help you kind of get through these very dense regulations that Rachel referred to earlier today. And then finally, we also have, it's not listed here, but we have a return to work decision tree flowchart. It's a one-page diagram that can help you, go through the process of, okay, how do we and when do we bring people back to work, returning to work after there's been a potential exposure to COVID-19. So we have those resources available to current clients. If you're not a current client, that's okay. We just, because we're going to be providing a little more specific legal advice, we just have to make sure we run a conflicts check. And what we'll do also just for this is if we sign in an engagement letter, there won't be any sort of upfront cost. There's not going to be any retainer required. It's just to ensure the attorney-client privilege and the attorney-client relationship is solidified so that we can start sending you these documents for your use. And the idea here is that you'll take these documents. You might find them helpful. If you've got any questions, you're more than welcome to reach out to us about it. We can help you review final drafts for compliance and that sort of thing. But we want to give you some resources, at least get you started. And as we discussed, we're here for you for any questions or concerns or assistance that you may need in complying with all of these laws that are coming out in 2021. So with that, I want to thank everyone for attending and your patience as we get through a lot of topics. I want to thank our speakers again for their hard work. I know it takes a lot of time to put these slides together. I know we're just here for an hour presentation, but there's a lot that goes behind the scenes. And I want to thank our team, our presentation team, Susan and others, for helping to put this together. So thanks, everyone, and have a great day.